My biggest message around implicit bias, no matter who we are, what we do, is reminding ourselves that we all have them. And when we call ourselves on it or someone calls us on it, not being offended by it, being,
Yeah.
like understanding, like, yes, even with all the training in the world, I mean, I'm amazed. When I started practicing law back in 1992, that was the time when companies were just starting to get really big on anti-harassment and
hmm
prevention training and so forth. And I look almost 30 years later and I'm like, all this preventive training, how is it that we still have
Yeah.
discrimination, harassment in the
Or
workplace?
The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. All right, well, welcome back to Mediator in the Middle, a podcast about mediation by mediators for lawyers and their clients. I'm your host, Abe Melamed, and we're really excited today to have a guest who we've been waiting a while to have because she has so much very valuable insight, and we're excited to have her here. Angela Reddock-Wright, who's a mediator and arbitrator in California. Angela's background is primarily in employment. I know Angela, you do some commercial work and some tort work as well, personal injury, things like that. But I think your claim to fame, at least the way I know it, and I think the world sees it, is you are a brilliant employment lawyer. You're someone who understands the very nuanced California employment law landscape, and you practiced employment law for 15 years before transitioning in many ways to investigations and then mediations. And so I think you have a lot of experience and skills. You've been named Southern California super lawyer for many years in a row, recognized by your peers. And I think also in some ways are known to be a champion for diversity, equity, and inclusion in the mediation practice, which is a big piece of the topic that we're going to speak about today. So before I introduce the topic, anything I missed about that introduction you think is important for people to know?
No, Abe, you're quite generous in your introduction. Thank you so much.
Of course, I try to be, but I can only do with what I have to work with. So some people I can't give the same introductions. Well, we're really happy to have you here. And the topic today that we're going to focus on is culture, diversity, civility, professionalism. I think there's a lot of different facets to the same overarching concept in the mediation process. And in particular, the way that lawyers interact with their clients and the mediators through the mediation process, and also things to be sensitive about for the mediator, for the lawyers, for everyone, about people's backgrounds, people's cultures, and the way that it's going to affect them in the mediation process. And I think that's the broad theme. The way that I would say it is, just be conscious of these things. That's the most critical thing. The person who doesn't ask, the person who doesn't try to be conscious, I think it's a problem. So that's kind of the broad topic. Anything you want to say right off the bat about that topic?
No, I think you kind of hit the nail on the head with some of the important topics of the day that we as mediators wrestle with and try to be sensitive to when we approach our mediation. So it'll be interesting to see if we can cover all of those topics.
I
They're
know.
all a conversation unto themselves.
Exactly. We pack a lot into a short time. But let me start with this, because I think the mediation process starts a long time before you actually get into the process. We did a great episode with Lee J. Berman about front loading the process, and that's been a pretty consistent theme. But the first thing that I think is most critical is to put the message out there to the lawyers coming into mediations. If you're aware of a cultural sensitivity with your client or with yourself, frankly, I think it's critical to inform the mediator up front. And a good mediator is going to ask those types of questions, but a lot of times it's nuances people don't recognize. So are there things you've experienced in your practice, experiences you've had either of people who were really
sensitive to these issues and you thought that's amazing, or people who were really insensitive to these issues and you thought this person could use some training?
So first you mentioned Lee J's name, and I can't let you mention his name and mine not piggyback on that and just say that I have great admiration for Lee J. And
Sure.
certainly when I was starting out as a mediator, and even to this day, he's someone that I looked up to and continue to look up to. So I love his term, front loading the process, because I'm very much a believer in that, once I see a mediation on my calendar, I reach out to counsel for both sides or all sides and let them know that, upon receiving their briefs, I would like to do a pre-mediation call with them. And the purpose of that call, one, if I haven't worked with counsel before, is to get to know them a bit outside of the mediation, and not to allow the mediation to be our first time meeting and interacting with one
Sure.
another. I think that's could be potential for not as great of a mediation as one might like, just because this pre-mediation call gives you a chance to also get a quick sense, granted not the sense that you get their full day, but what the lawyer's personality is like, I even asked them, I'm like, do you have any pet peeves about mediation that I should be aware of?
Yeah.
Pitfalls,
But what do you not like that other mediators do that I shouldn't do?
Right? Yeah, I don't quite ask it in that way, but definitely I ask them what do they like most about certain mediation styles, or styles that they would immediately turn them off, or parts of the process that would immediately turn them off. But I definitely believe in the front loading concept and in the pre-mediation call. And as you stated, part of what can be accomplished in that call is asking, I frame it this way. I say, are there any particular sensitivities that I should be aware of as it relates to the case and or your client? And I also let them know that I very much see the mediation process as a collaborative process, meaning that although you're hiring me to mediate your case, presumably based on my substantive expertise, based on my style as a mediator and what they may have heard about my style as a mediator. But even in hiring me to sort of help carry the day, that I see it as a collaborative process between counsel and their client. And so being aware of any sensitivities, whether it be cultural sensitivities or others, that them equipping me with that knowledge ahead of time can only help me better serve them. So I most often see the cultural sensitivities come up when it comes to issues of race in particular. In fact, I think many of the cases that I mediate are race discrimination cases and gender discrimination cases. But for example, if there's a Hispanic or Latino complainant, the attorney may alert me that there may be, whether English is their first language or not, or whether they're going to have an interpreter. Or I've seen this in my cases last year in 2022. One big theme I saw is, in employment cases, we often ask, a critical aspect of employment cases is whether there's damages for emotional distress and whether a person has treated with a therapist or not. That tends to be kind of a turning point of how much the defense will value an emotional distress claim. And so in a number of my cases last year, in particular where there was a male Hispanic plaintiff, counsel would let me know early, in this pre-mediation call or during the mediation, that the person possibly did not receive treatment because culturally it's frowned upon for males, and I'm sure this is broad stroke, and it's not true across the board. But in these cases, they stated that culturally it was frowned upon for males to go to therapy.
Sure.
That that
there's a machismo that's, and I think that's exactly right.
Just kind of deal with it and to man up, so to speak, right?
Yeah.
Even in instances of females sometimes, and this happens a lot with Black female plaintiffs that I see, and I know from my own life, for many, many years, we're like Black women, they just hold the weight of the world. And so we just deal with things and we don't always seek therapy. Now it's becoming more, with all the education around mental health and the importance of all of us getting the support that we need in terms of mental health. We
Yeah.
see a lot more people treating, and the stigma of treatment going away, no matter what cultural association a person has. But
Yeah. I
yes,
think
to
that's a
answer
great
your
one.
questions, those pre-mediation calls are ideal to start to get to some of those issues.
I think that's a perfect example, or those are a couple of great examples. And I think that's exactly right about what's known to be at least the Hispanic male community, that it is often, unfortunately for them, just frowned upon, not seen as something that they were able to do. And I do think that that's an important cultural sensitivity that maybe the other side, in this case, an employment case, the defendants might not acknowledge outright, but in reality, they have to know that these are the types of issues that are going to come up in front of a jury. These are the types of things that are going to be able to be explained by a plaintiff's counsel. And so I think that's a great example. And I think, by the way, the language piece is critical, because I've had that a handful of times, and I actually speak a decent-ish Spanish.
I
So
remember you telling me that.
yeah,
Mhm.
I can get through a mediation with a Spanish speaking client that doesn't have a translator, but it definitely changes the tenor. It makes it more difficult. And a good lawyer is going to prep me in advance. Hey, just so you know, we're going to have a paralegal who's going to be there to translate, or we're going to have a family member. But I've had a couple times where I showed up to the mediation and they didn't speak any English. I even had one time where the plaintiff didn't speak any English and the plaintiff's attorney didn't speak any Spanish and didn't have a translator. And that was a little bit of a mess, but
Yeah.
the case still got settled. So I think those are great examples of things that, the lawyers should be looking out for. Let the mediator know in advance. I think an interesting piece to those pre-mediation phone calls that I try to be a little sensitive to, just because of my own religious background, but I'm curious what your experience has been, is asking about the religious practices of the individuals. With Orthodox Jews, and there are very, many different levels and practices, but with Orthodox Jews, oftentimes you'll have issues where a male participant is not comfortable shaking hands with a female. And that's more common of an issue in in-person mediations, which I know a lot of us are doing very few of. But you have that sort of issue. You'll have food issues, kosher food, things like that. I think that crosses over into some other religions too. And, when you have a mediation during Ramadan with a Muslim client or something like that, and you want to make sure not to be offending anyone by offering food when they might be fasting, or by not having kosher options, or, things like that. Are there issues in other practices, other areas of life that you find it's important, maybe focused on the religion that I haven't focused on, that you have found become an issue or can become an issue if they're not flagged in advance of the mediation?
Yes, I can't say that I've had any cases so far in my career where, for example, I've mediated with an Orthodox Jew and or someone that's Muslim or something like that, and those types of issues. Not I'm maybe I have mediated with someone who's Orthodox Jew and didn't know it,
Right.
or someone who's Muslim and didn't know it, but where any particular issues associated with their religion were at the forefront or something that we needed to consider as a part of the mediation. I myself, I'm a Christian, and I think, part of the reputation that I have as a mediator is she's someone who is sensitive to issues of race and gender,
Mhm.
obviously because of my own protected status,
Sure.
but I'm pretty vocal about my faith as well. And so I think I'm considered for a lot of cases when there's kind of a Christian theme, or
Religious
say
component.
a religious component, and the plaintiff or the respondent or the defendant may have potential religious leanings or Christian
Mhm.
leanings or beliefs, or the case involves a church or a religious institution. And so in those cases, I tend to kind of know, like, oh, okay, maybe I was picked for this
For that
reason.
reason,
And I
right?
will ask, even in a pre-mediation call, hey, why did you pick me for this case? Is there a particular perspective or insight that you think I may be able to offer, in addition to my expertise as an employment
Sure.
lawyer or as a mediator? But was there any thought about any other particular viewpoint or sensitivities that I might bring to the mediation? So in those cases where I find out even if it's not presented as, oh, be aware that this plaintiff is Christian and you should approach them in a certain way. But in the course of getting to know their client, if I learn that, then if it's appropriate, I will let that person know, generally in a very passive kind of way, like, oh, I'm a person of faith too. I understand
Yeah.
that you've been praying about this and that this is weighing on you, like
Mhm.
really using my understanding of this particular faith to kind of build rapport and trust
Yeah.
on either side where it's relevant.
Which is critical. I think that building that trust is one of the most important things for any mediator early on in the mediation process. And that's why I think this is such an important issue, because I've heard stories, it's mostly war stories from others, of bad experiences where someone was not made aware of a cultural issue, and then right away they've offended someone. They reached out to shake the hand, or they came in dressed a little less conservatively because they were not used to it. And there's a very conservative religious person there who just can't even look up at them. And then it's just, now you have to, it's no longer building rapport, it's digging your way out of that hole to then start again. Both can be a landmine as something, really people need to look to avoid, but also it could be a great way to build that rapport. And I think that's exactly right. I do get brought in sometimes for Jewish cases or Orthodox Jewish cases, just because I'll be able to understand the culture and the issue. And I think I'd like to see more mediators selected because they have those unique perspectives. But I think at the same time, there are some great mediators out there who have an experience that can still build that rapport. But I think at least being sensitive to those things, being
Right.
able to acknowledge it. And then another great thing that I think is important for anyone involved in the process, it could be the lawyer, it could be the client, it could be the mediator, is in the event that you encounter that issue where you've said something or done something that might have offended the person, I find saying, I really apologize, I didn't realize this was going to offend you, but tell me more about your religion, about your race, about whatever it is that, is the subject of that. People tend to really like to talk about those backgrounds and that experience. And I think that's a good way to kind of backtrack it. I remember one of my mentors who was a mediator once was in a mediation in South America. And she, I subscribe to the same philosophy about clothing and mediation. I start with a suit and a tie. And then at some point, the jacket comes off. And then at some point, the tie comes off. And it's symbolic of the stages of the mediation. And she said she had done that about halfway through the mediation. She took her jacket off and, was wearing a regular blouse underneath. And it offended the person on the other side, and it shut the whole thing down.
Oh, wow.
So, yeah,
Wow.
hopefully you and I, neither of us experienced that. But I think being sensitive to this and being sensitive even to the clothing, it was a thread on LinkedIn recently. I don't know if you saw that or not, but a handful of people were talking about the clothing lawyers and mediators should be wearing in the mediation process. Do you have any
Oh, I
feelings
missed
about that?
that. Okay.
Yeah.
Was the leaning toward maintaining business dress or more casual dress?
It was really actually fascinating that you had a diversity of responses. And I think that's just more indicative of how important it is to be thoughtful about this. But I kind of said, look, this is the way I do it. And then I had a response from someone who had trained in French mediation thought and had, said, well, French people tend to be more fashionable. And if you come in a suit and a tie, it's actually offensive almost. And
Okay.
it was really interesting. I don't know. Do you have any thoughts on that? What the lawyers, the clients should be wearing to mediation?
For me personally, I choose to keep it kind of traditional business dress with my own touch, like I always have a signature piece of a necklace on or something like that. I try to wear something colorful, not like, overly colorful. I'm sensitive to wearing colors like red because I know they invite kind of a certain response sometimes.
Yeah, they evoke
But I
anger
try to
sometimes.
wear cool, bright colors, particularly being on Zoom because I think it could get kind of distant and dark and so forth. So I try to use what I wear, my colors, to kind of lighten things up, not lighten the moment up, but just to kind of show that I'm approachable, friendly, etc.
Yeah.
So I'm still the business dress side. I mean, because the other, consideration of that for a woman, I think, is there all sorts of, I won't even just limit it to a woman, but there are all sorts of implicit biases that still exist in our society. So I'm very sensitive to if there are biases because I'm a woman of color. So the last thing I want to do is kind of show up in my casual, Friday casual outfit. And that raises questions about,
Mhm.
okay, is she professional? Is she qualified, etc.? So I think dress and look is an immediate way to, establish some form of credibility, particularly if you fall into a category where implicit biases can
Yeah.
run rampant
We have
about.
to overcome some hurdle to begin with.
Mhm.
And, I get that about my age sometimes. So I can't relate.
Exactly. That's why
Yeah.
I opened it up. I said not even limited to
Yeah.
gender or race, and I specifically in the back of my head was thinking age,
You're thinking,
like if
hey,
you showed up like, hey, the
if I was in
latest
flip flops and a
trends,
t-shirt, no one would take
right?
me seriously. It's the suit and tie and the glasses. No,
Right,
I think
right.
that's a great point, and I actually want to. That's a great way to pivot into the topic of implicit and explicit bias, which I'm sure is something that you've had to grapple with in your own life, and that you have a lot of experience with in the legal field. But I'm really curious, most as a mediator, what you find, what's advice that you can offer to the lawyers out there prepping for those mediations about maybe how they can be more sensitive to their own clients' cultural sensitivities and concerns about bias. Maybe their client has a concern about bias. Maybe it's in the selection of the mediator because of the client's concerns about that. Anything on that topic you want to focus on?
Yes, I mean, my biggest message around implicit bias, no matter who we are, what we do, is reminding ourselves that we all have them. And when we call ourselves on it or someone calls us on it, not being offended by it, being,
Yeah.
like understanding, like, yes, even with all the training in the world, I mean, I'm amazed, when I started practicing law back in 1992, that was the time when companies were just starting to get really big on, anti-harassment and
Mhm.
prevention training and so forth. And so I'm almost 30 years into it. And I look almost 30 years later and I'm like, with all the trainings, and some of the training has just really advanced over the years and it's just so progressive and on target and so forth. With all this preventive training, how's it that we still have
Yeah.
discrimination, harassment in the
Or
workplace?
or any of these things.
Because
It's yeah,
we're
it
human,
boggles my
right? And
mind.
we all
Yeah.
have our biases. So I think being aware of your own biases, being very conscientious about working on those and checking being able to check yourself when you notice it. So one of the things, for example, I'm really training myself on is being conscious of how we use pronouns now,
Mhm.
right?
Yeah.
And I'm like many people, I'm very quick to say, hey, you guys, or hey, girls, whatever
Yeah. It's just natural.
the
It's
term to
yeah.
address someone or to speak or to reference individuals. And so I'm being a lot more thoughtful
Mhm.
about in my everyday language, not just in formal mediations or formal legal processes or what have you, but being a lot more thoughtful how I use pronouns and refer to people. And the reason I'm challenging myself to that is because if I get it right just in my everyday use of language, then when I am in a mediation, it'll come more
Yeah,
naturally.
it's more
It won't
natural.
be kind of, something that's perceived as contrived or what have you.
Yeah.
So all of that to say is I think we're in a place of the world of implicit bias where almost everybody's pretty much had some training and exposure to it.
Mhm.
And now it's about internalizing it in a positive way, figuring out what your biases and your leanings are, and holding yourself accountable to it in all of your engagements, whether it be with the client, with opposing counsel, with the mediator. And I think once there's that personal accountability, it makes a difference in terms of how we engage with one another. A couple of specific ways that I see it in mediation is let's say as a plaintiff, you have a person of color who was a low wage earner, right? what I sometimes see coming out of the defense room, granted, there's this, calculation of damages and how damages could be calculated.
Yeah.
But let's say there's a difference between the economic damages and the alleged emotional distress damages. What I will sometimes hear coming out of the defense room is, hey, this person is getting twice what they made, or this,
Yeah.
comments that almost suggest that the person doesn't, because they were a low wage earner, they don't quite deserve bigger consideration for other damages or special damages.
Mhm.
And again, the damages have to add up, and there's a way that we do that, and there are all sorts of factors. But when I hear it adds up, a person almost doesn't deserve it, that makes me tinge a little bit, right?
Right.
Or
Yeah.
even in the reverse, if a plaintiff's lawyer perhaps is not fighting as strongly for their client or advocating because they're like, oh, this is a good day for them, it's more than
Yeah.
they would have ever made in life, that makes me tinge a little bit. So again, not valuing cases solely based on our perceptions of the person,
The person, yeah.
plaintiff that's before us. And it's a fine line, because again, I want to be clear, I'm not ignoring, and of course I'm aware that there's a very, specific
damages
way in which we
calculation
go
has
about
to-
calculating damages.
Sure.
But the way in which we talk about individuals and what their cases should settle for is something I'm very, very sensitive to.
Yeah, I think that's an extremely important point, and I unfortunately have actually seen it explicit, not just implicit. I've had counsel sometimes on both sides say something to the effect of, well, those kinds of people, or that kind of a lawyer, referring to a lawyer that represents a community, a Chinese lawyer who's representing a Chinese client. And it's, oh, well, those kinds of lawyers and things like that. And that's really unfortunate to hear. And I will shut it down when it comes up. But I think that's
underestimating the lawyer because, like, to your point, because
Yeah.
of your association with whatever perceptions you have of that person, or just underestimating them merely because they're a plaintiff's lawyer. And I did both. I was a defense lawyer, and when I went out on my own, I started to do plaintiff's work. And I have met I meet daily amazing attorneys on both sides. And so I think, and this maybe leads to the whole civility part of just attorneys having to respect each other, just for the mere fact that we're all barred together and we're all in this together, You
would think anyway, but not everyone takes it so seriously. But I think that's a great pivot point into that conversation, because that is something that the lawyers need to be thinking about in advance of the mediation. It's something that the clients need to be aware of. And, there are times where you bring the lawyers together for an attorney-only meeting, and there's a great episode with Gig on that issue. But
I have to watch that.
That's a good one. Oh yeah, It's a really, really good one. I've started to adopt having more of these joint attorney meetings based on that episode alone. But I think I experienced, when I was a litigator, a number of times where those meetings got out of hand, and it was just completely unacceptable. And then they told me to stop yelling. No, I'm kidding. It got out of hand because I was trying to be civil and lay out the case and talk about issues, and the defense attorney or the plaintiff's attorney, depending on which side I was working on, was just obnoxious, was mean, was just downright not civil. And a good mediator will usually shut that down. It becomes not productive anymore. But what's the message that I think you would want the world to know, or the lawyers out there to know, about that process, about the dangers of acting that way in the mediation process? And maybe it's just towards the outcome of a settlement. It affects the ability to settle cases. But what are your thoughts?
Well, among my favorite cases to mediate are ones where the lawyers, even pre-mediation, acknowledge that they've had a good set of communications, that they respect one another. Because in my pre-mediation calls, I will always ask, oh, what's the relationship like with the opposing counsel? What have the conversations been? What have the tenor of those conversations been? And where both sides say, yeah, I have great respect for the other lawyer, they're good lawyers, our communications have been civil. And then they'll pivot and say, but that said, we obviously have to advocate for our client. And this is where we think they're missing the issue or the other side's missing the
Right.
issue or what have you. And to me, that's a healthy approach to all litigation, where you come into the litigation with the expectation that the relationships are going to be civil, and that even if you find yourself getting into kind of a fight about something, that it's a fight about the issues and not a fight
Right.
about each
About the
other
people.
personally, right? I think that's dangerous. I think it's dangerous for our profession as a whole, and it certainly doesn't help to get cases resolved. And I kind of go back and forth on whether to bring attorneys into the room together. I don't do it automatically, and it's
Mhm.
really on a case by case basis. But if the relationship between the lawyers is civil, and I do think there's a breakdown in understanding of a certain substantive issue, or that either lawyer needs to kind of hear from the other
The other
lawyer
side.
a certain issue, or
Yeah.
yes, my client believes this and we're not moving, like if they're just not believing me as the mediator. And I feel that I need to bring them in to have that discussion or to work through an issue
Yeah.
outside of the presence of their client. I tend to only do that where I know the relationship is at minimum respectful, and
Right.
that it's
You know
not
that
going to turn into a screaming match between the attorneys, or that one attorney is going to walk away feeling put upon or bullied or what have you. And if I
Yeah.
find that happening in the course of a joint session with the attorneys, I will immediately say, counsel, that's inappropriate. That's not the purpose of my bringing us together. And if we can't talk civilly to one another and one at a time and not over each other, then this was not a good idea, and I'll just suspend it right away. But if I know going in that the relationship was hostile, even there have been times I suggested, hey, maybe we should, and the attorney like, no, that's not a
Nope.
good
No.
idea. And I accept that. I don't try to push it,
Yeah.
because the last thing I want is things to fall apart as a result of that exchange between counsel.
Yeah, I think that's a great point. I've even had some times where one of the lawyers said, "Oh, we have a great relationship. I have so much respect for them," and then go to the other side and like, I don't know what they're talking about. That guy's the worst.
Right.
I think the point about not making personal attacks and attacking the issues, not the person, I think is really critical. I remember one of my favorite decisions from a judge, a great judge in New York in the federal court, when I was litigating a case and defense counsel, I was a plaintiff's lawyer, defense counsel, wrote a scathing letter basically attacking me personally. And the judge's order was just, the court does not need a diatribe. Counsel's instructed to state exactly how the facts do not raise the right to relief above a speculative level, something like that. But I think that the mediators recognize the good lawyers and the bad lawyers, the ones who are going to use those personal attacks. And I think that's another thing for the lawyers to understand.
And I'd be careful to say good versus bad, but I mean, because the other thing I think about when I see a lawyer that seems to be unhappy or just generally just irritated,
Mhm.
I say, you know what, there's something else going on
Yeah.
with that lawyer that has nothing to do with me, nothing to do with this process. Maybe
Just a
they're
bad day
really
sometimes.
unhappy, or don't like practicing, or that's just, I mean, I think
There are lawyers who don't like practicing law. Shocking. I thought we're the
That's
happiest
another
profession.
conversation. But I
No,
think back to my first job out of law school, which it was a boutique employment litigation firm. And I'll just use the first name. There was an attorney named Christopher, and I had to work with him a lot as an associate. And he was just always in a bad mood, very
Mhm.
particular about every little thing. But looking back 30 years later, I am so grateful for Christopher, because everything I know and becoming a polished lawyer and being, a great writer and analytical thinker, all that started with him. But
Yeah.
as you were just like, every day you're like, what's wrong with you?
Yeah.
Why are you so irritated all the time? But
What happened in the
sometimes
morning?
greatness
Yeah.
comes from those personalities.
Oh, for sure. I think that there are many lawyers who just have a bad day or who have a bad experience, or their client is upset with them about something, and it's, getting to the underlying issue is important. And I think actually that's a great pivot point into another topic. And this is something I'm sure you could spend hours talking about, which is trauma-informed mediation. I think it's more of a broad topic than even that, which is just psychologically informed mediation. I think that it's a shame there aren't more lawyers and mediators out there who are looking out for that underlying issue and understand that when someone presents with symptoms, it's usually because of an underlying problem. And I look, every great mediator out there, that's their job. That's what we all know is our job is to say, okay, this is not just about the money. Let's talk about why you're upset. This is not just about whatever issue it is. But I think that in particular, when you get to sensitive topics in cases, sensitive cases, sexual harassment, rape, assault, things like that, understanding the way that the person who's experienced what they've experienced is going to react, is going to just present, is, I think, a critical thing. And I think mediators need to learn as much as they can about this. But what I would like to focus on and get your thoughts about is how we can give lawyers out there the tools to recognize this with their own clients, to be conscious of it, to flag it for the mediator, and to try to work with the mediator in a way that will result in a helpful and healthy process. And, you know, I mediated one of the last cases before I shifted my practice to mediation when I was representing a plaintiff who was raped. And the mediator came in and said something to her like, if you can't even sit through today and talk about this, how are you going to sit through a trial? And the message wasn't wrong. It's certainly an important point that we make as mediators. Listen, you need to understand how uncomfortable it's going to be, but that was the absolute wrong thing to say to someone who had been through what she had been through, and it broke everything down. So I think that's an example of what I wouldn't want to see other mediators doing. But what do you think about for the lawyers themselves? What can we give them in terms of tools to understand and recognize that their clients might be in a position where that's something you need to flag for the mediator for the mediation process, to make sure it doesn't trigger them, to make sure it becomes a productive process?
Great question and topic, one that I've written about and talked about extensively. But just before we go there, I just wanted to go back to lawyers that aren't always happy or we don't see their best sides all the time. You raised a good point that as mediators, we also have to be sensitive to the fact that we don't know everything. We just know this case that's before us, what's been provided to us in the brief and any pre-mediation conversations, but we don't know what, you know, and I usually will ask a lawyer, what's your relationship like with your client, et cetera. They don't usually provide, you know, honest, you know, insight to that, but we don't really know what other pressures are on that lawyer, whether it be from the client or their firm or just, you know, more broadly speaking. And so I think part of our jobs as a mediator is to be sensitive to that, not just for their clients, but to be sensitive to making sure that the lawyer feels supported in the mediation process. So acknowledging the good work of the attorney, when a lawyer has made a point in their brief or in the context of the mediation itself, like, thank you for that. When I read this in your brief, it really helped me to understand this, right? And just, I think without it being contrived and overstated, but just finding ways to kind of let the lawyer know you're there for them,
you're there
and
to support
you're also
them,
there for their clients as well.
Like your introduction at the beginning of the podcast, you can only work with what you have. I think you're right. It has to be genuine. But when you see, I always will say in front of the client, wow, that was a really great brief. I really appreciate that you gave me all this information in advance. You want to make sure, I really applaud you for selecting this lawyer as your lawyer. We all know they're a great lawyer. Those are sorts of terms. And I had a case that I'm mediating next week where I got the brief yesterday, and it was just a beautiful brief. I mean, perfect excerpts from depositions and links to every exhibit. And I made a point to let the client and the in-house counsel on the chain know this was really quality work. So I think that's a great point.
That's awesome. But on this topic of trauma-informed mediation, I honestly think, you know, as you said, many mediators, we go through this type of training and we're sensitized to these issues. I think we just need to see more of this training in law schools and
Yeah,
in law firms and in our MCLEs. One of the things I admire about kind of the more traditional corporate world is that they tend to be much further ahead than law firms in terms of embracing some new concepts and things, like
sure.
the whole concept of meditation in the workplace and being peaceful and that calm. We see that happening in the business world. Business executives are embracing this. They're making sure they're
Yeah,
training people on it, issues of DEI, etc. And we see it in our law firms, but it hasn't been like an overwhelming attempt to educate lawyers on, from what I have seen, on what it means to be trauma informed, on both sides. Because even the
hmm,
defense said, well, why would we need to know that? You need to know it so that you know how best to litigate this case against this
yeah.
plaintiff that perhaps has been really traumatized by their life's experiences or by whatever the subject matter of the lawsuit is. But I think it goes back to what we were saying with DEI and implicit bias. The first step, besides education, to becoming trauma informed is as basic as just realizing, even if you only focus on this last 3 years, is that we have all gone through like a traumatic,
Oh yeah,
life experience, more traumatic for some. Many have lost their lives or have loved ones who've lost
yeah.
their lives. So if nothing else, whether it be in a mediation or court hearing or deposition or what have you, we all should walk in with this sense of like, if we're still here on, January 2023, we all have survived a
We've
lot.
survived something big. Yeah,
Right. And we don't know what every person's personal experience was like, but we have to assume that everyone was touched by the COVID-19 pandemic in some way. So even if
oh
you
yeah.
can start there, like, doesn't even have to be as fortunate as something like a sexual assault or rape or discrimination or what have you, but just starting with the fact that the entire world of human beings and species,
Was traumatized by this.
experience this. And if you
Yeah.
can approach life in a different way just from that particular experience, it'll automatically sensitize you to the person across the table from you.
I think
So it
that's a great
starts with
point.
wanting to understand, wanting to be more sensitive to these issues, and then deciding to be.
Choosing to be. Yeah. And, I think that that's a great point about the pandemic. I hadn't even thought about tapping into that as a resource of recognizing the traumas that other people have been through. But absolutely, it's traumatized everyone, whether it's loved ones that have passed. My wife was an ER nurse during the height of the
Oh,
pandemic,
wow.
and it
Wow.
was it was terrifying.
Yeah.
So, you don't have to have racial, discrimination or have been beaten by the police or have been sexually assaulted in the workplace to recognize that those people often will have a more traumatic response, or it'll be more important to be sensitive to it. But I think that's a great way to frame it, that any lawyer out there can tap into that. Just think about what it was like April of, the pandemic when it was
2020. Yeah.
first, exactly. And to be conscious of those sorts of things in just the way that we interact with anyone. But I think that the last thing you said is maybe the most critical, and is you have to want to tap into it. You have to want to be someone who recognizes these issues. And I think, I like to think, and I know that you do because of all your responses before, I like to think there's good in everyone and that everyone wants to tap into this in order just to be a better human being and more sensitive. But at the same time, lawyers out there, I mean, this is how you get your cases settled or won. And I think if you just think about it, even from that pragmatic perspective, if you're not sensitive to these issues and you don't realize something, you don't flag it, and it blows up something that could have been a great outcome for your client and for yourself, I think it's a disservice to the client and a disservice to yourself.
Yeah,
So
you raise a good point. And then, I mean, I like to think that most employment cases, plaintiffs' lawyers are, whether it's a formal sensitivity to it or informal, are kind of trauma informed and sensitive because
yeah,
they relate, their
it's the type
client's
of work they
perspective in
do.
their briefs and how they present their client's case, the impact something has had on them. But again, I have so many types of favorite cases, but among my favorite types of cases is when I hear defense lawyers, acknowledge, like, we understand that this may have had this impact on this person, or this person may be experiencing some other issues, associated with childhood abuse or what
Mhm.
have you. But even in acknowledging that, here's our position. So,
Sure.
but just for them to acknowledge it as opposed to just completely dismiss it and it's irrelevant and, why
Yeah.
are we talking about it? I think that's a disservice to the process, a disservice to their client in terms of being able to assess the true value of a case for purposes of mediation, and a disservice to the person because it means you kind of walk around just not believing people, not being understanding of the types of
Mhm.
things that people go through, and that's dangerous for all of us.
I agree. I think that's a great point. And I think, especially on the defense side, you're right. The great defense lawyers, the ones that I love working with, are the ones who are able to be candid about the strengths and weaknesses. And it's not just about what the traumatic experience was. It might be about a good legal argument on the other side.
Mhm.
But to be able to acknowledge it, recognize it, and then explain how their perspective might be different, I think is a huge credibility win for that party. So I think that's a great point. And I think that the more the lawyers think about these things in advance of the mediation, the more they can also maybe be more realistic about how they value the cases and how they recommend the valuation to their clients. I don't know if that's something that you've seen really successful, but I think that a good lawyer who understands this plaintiff is going to see more money from a jury because of their reaction versus, on the defense side, I need to pay more because I recognize that this person has this background, whatever it might be. And to be more thoughtful about that piece as it goes into it, because you're right. I think the economic damages in these types of employment cases often are easier to calculate. The emotional distress is a big question mark. So
Yes.
any last minute thoughts on that topic before we kind of turn
No,
to
just
wrapping
that,
up? Yeah.
that's true. When there's greater sensitivity to issues of race, gender, traumatic experiences in life, I think it creates a process that is that yields a better result, even in the
Mhm.
process. Even if you don't settle the case, it just kind of yields a better result in the conversation, because a conversation is not just like, what are they talking about? They're crazy.
Where are they coming from?
It's like, we
Yeah.
hear you. But again, this is why this is different, or we are valuing that, but we're only valuing it in this way with this amount versus this amount. But
Right.
it makes for a much more informed discussion that is less frustrating for both sides.
I think
And the
that's a
last
great
thing I'll
point.
say is, so if a mediator finds their self, in a situation where either side doesn't seem to be sensitized to issues of bias or trauma or what have you, that's that's what we're hired for, right? Of course, it's a collaborative process and so forth, but we're also hired to kind of see where these
Mhm.
issues, and to be a part of educating the parties in counsel when we see something. Of course, we got to be thoughtful and strategic about how we do that, to be careful not to offend. But I would say that's where our jobs really kick in when it
Yeah.
comes times to evaluating a case, when we're asked to be a part of the evaluative process, when it comes time to, like, and for me, assuming I'm hired a lot because I'm a woman of color, and that's a perspective that either side wants, when the window is open for me to kind of shed some light based on that, I do it, because I know that that's part of the
Part of why you were
insight
hired.
that counsel and their clients were looking for in terms of hiring me. I would say that's why
That's why we do
do
what
what
we
we
do. That's
do
why
and
we're
why we're
brought
hired.
in.
And if we're afraid to do that, then we probably shouldn't be doing this
We
kind
should
of
go back to litigating, or no, I'm kidding. No, I think that's exactly right. It's a great point. And I think that some of the best experiences I've had surrounding this topic were where a lawyer said to me, I think it's important to have you as the mediator because of this specific perspective. I don't even understand how to connect with my client and change the way they see things. I'm
Mhm.
hoping you can. And getting that tip from that person is so critical. And that's, I think, the biggest message I have for all the lawyers out there is, look out for these issues, be focused on it, try to see if there's something that you need to flag, and then flag it for us, so that even if you yourself may not be able to, you don't know how to handle this, frankly, you may not have that background, but you understand to tip us off as the mediator to be sensitive to it.
Right,
So
right, exactly.
I think it's great. Well, the last question I always like to ask every guest is, what do you love most about mediation? Why do you do it all day, every day?
I love being a mediator because I like being a part of the process of helping parties resolve their cases. I mean, there's nothing more fulfilling than that, even if a case doesn't settle, but you feel like you help get the parties to a new understanding and maybe help them settle the case later. It's like a feeling of exhilaration that, I
Little
haven't
high.
been known to use like external sources, substances or anything for
Yeah.
getting a feeling, but I
Coffee.
can imagine the feeling is similar of like, wow, you just are on a high after mediating a case. So
Yeah.
it's emotional and it's draining, at the same time, but there's just such a sense of fulfillment for me at the end of each day and each mediation. And there's also something that happens, like every mediation you go to is almost like improv, like you don't know what to expect. Even if you do the pre-mediation calls, you have the briefs, etc., you don't really know what's going to happen until you're
you're in it,
right? But they're always so far, knock on wood, a place in the mediation where you're just like, okay, we're here, we're grooving. You got a good strong sense of the factual issues. You feel like that you got the parties talking to one another, and the numbers are kind of, they may be moving slowly or quickly,
but
or
it's
what have you,
moving.
but there's just that moment where you're like, okay, we could do this. We can get this settled. Let's go for it. And as the mediator, you really become a cheerleader for the process, and a person who keeps the parties motivated and incentivized to keep the conversation going.
To keep going until it's done. That's when my jacket comes off and the sleeves roll up, usually, is that moment when you start feeling this momentum,
Yep. Yeah.
And then when the lawyer at the end says, at lunchtime, I thought this case was never going to settle, that's really rewarding.
Yeah.
So,
I say in my mediations every day, of like, I see miracles happen every day, folks. So don't give up. Let's keep it going. The ties do change. You just got to believe in the process. And
it's really faith affirming, seeing those miracles happen.
Yeah.
Well, I appreciate you taking the time. And the one thing I'll end with is I saw a fun fact that you're a fan of bowling. I don't know if you know that I am as well.
Oh my goodness, we gotta go bowling.
We gotta find some time. You have a ball and shoes? I've got a couple, at home. We try to go every Tuesday night. Oh yeah.
Oh my goodness. My husband and I, we're like trying to find a hobby to get that we could do weekly together. So we're thinking about joining.
My wife hates it. So she does not enjoy bowling. She enjoys watching me bowl, but she hates the actual process. I love it. I'm like,
oh wow, it's good exercise. Yeah, my dad is military army, and in the army they bowl a lot. They play a lot of softball.
Yeah,
he's very active, and he's in the Bowlers Hall of Fame for having bowled a perfect game.
Wow.
So one of the things,
a sanctioned perfect game. Wow.
From an early age was how to bowl. So
what's your high score?
Well, I don't get to bowl as often as I used to, but I'm sure it's something in the 200s.
In the twos,
I can't remember exactly.
Same.
Who's the comedian that does like, what's his name? Comedians in Cars or something like that.
Yeah, comedians in cars with coffee, or coffee in cars with comedians.
Right.
That's Jerry Seinfeld, right?
Yeah, yes, Jerry Seinfeld. I'm like, oh, you can like take your show on the road. You can like bowlers and mediation and bowling.
I love it. I love it. Mediation and
camera crew.
We got to think about an acronym type of name that works well with it. But
right.
Well, I'm going to take you up on that. We're going to compete sometime. But thank you so much for taking the time, Angela. I really appreciate it. I know the listeners really do. You have a wealth of knowledge and experience, and really a very unique perspective that I see clearly was fashioned by your life experiences. So I appreciate it. I'm sure everyone that listens will appreciate it. And thank you for taking the time.
Thank you so much. My pleasure.
Anyone who wants to find Angela, the link to her bio will be on the podcast episode as well. Thank
Thank
you.
you.
Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. Thank you. To book a mediation with Abe Melamed, the creative mediator, please email abe@melamedmediation.com. That's abe@melamedmediation.com. Or give me a call at 510-842-7277.